All right, and then we're going to go live in 3, 2, 1. We're live. Looks like we got a decent amount of people in here. We can begin whenever you guys are ready.
Okay, yeah. All right, I think we're going to get started here. So welcome everybody to this presentation from the MDTC on from our appellate section, Preserve It or Lose It, Creating a Record That Works. Just basically trying to aim this at discussing a lot of the common pitfalls, some useful tips in building a record for at the trial court level for use in an eventual appeal, whether it's from a post trial or from more likely a dispositive motion or issues like that. And maybe discuss some of the record building decisions that can kind of control outcomes on appeal, some things to look out for, good tips, and things like that. Um, Thank you all again. This is one of the perks of the MDTC, having presentations like this or having resources like the panelists we have here. I don't know if everybody is a member that is participating, but if you're not, I would consider definitely signing up because this is, these are very useful things to have. Um, so, with that in mind, I'll just introduce our panelists here. I'm Grant Jaskulski. I work for Houston and Van Hellemont as a appellate attorney there. I'm also a co-chair of the appellate section of the MDTC and a member of the amicus committee, as all of our panelists are. And I will introduce those panelists. First, we have Broaddus. He is a leading appellate advocate at Smith Hoggy and has more than 2 decades of experience in litigation and insurance matters. He has argued more than 150 cases in the Michigan Court of Appeals and also argued multiple cases in the Michigan Supreme Court and the United States Courts of Appeal for the Sixth Circuit. Phil DeRosier is the co-chair of the Appeals and Advocacy Practice Group at Dickinson Wright. He has more than 20 years of experience working on appeals in front of the Michigan Supreme Court and Court of Appeals, as well as the United States Circuit Courts of Appeals. He had previously been a chair on the State Bar's Appellate Practice section and is a contributing author to ICLE's Michigan Appellate Handbook. Adam Ratliff is a partner at Warner Norcross and Judd who focuses on complex and high stakes commercial disputes, but also specializes in appeals in both our state courts and throughout the country and in the federal courts of appeals, including the United States Supreme Court. And Nathan Scherbarth is a shareholder and team leader of the appellate group at Zosmer. He has handled hundreds of matters on appeal in Michigan appellate courts as well as in the Sixth Circuit, and started his legal career at the Court of Appeals, analyzing the lower court and appellate records, drafting research report, and preparing proposed opinions. And I'm going to basically kind of lead some questions and try to lead the discussion here. But of course, if anybody who is attending has any questions, please do not hesitate to put them in the chat, and we will try to answer them if we can. And just so please do not hesitate to chime in. But just kind of starting out for our panel, just basically, if can we just explain kind of Michigan's raise or waive rule when it comes to appeals and try to kind of analyze why that's so important when it comes to the trial court record?
So I'm happy to take that if no one else or if anyone else wanted to chime in. But so the razor wave rule we're talking about is the rule with respect to preservation in civil cases. And I think there's a common misconception among a lot of attorneys, appellate and trial attorneys, that the fact that something isn't preserved in a civil case doesn't necessarily preclude consideration by the Court of Appeals. The razor wave rule is essentially that if it's not been raised in the trial court, it's not to be considered by the Court of Appeals. Now, that is not a hard and fast rule. The Court of Appeals does occasionally stray from that and say, well, we'll review something for plain error. But There was a 2023 case, Talus Oil, that kind of reinvigorated, restated that raise or waive rule as it relates to civil cases. The rule is different in criminal cases. It's a little more forgiving, but that's, kind of the nature of the litigation. In a civil case, the courts assume that your attorneys are doing a good job of raising those issues that they want appealed at the trial court. So it's kind of the cautionary guideposts that we have to deal with any appellate issue. It really needs to be raised in the trial court. Now, traditionally, there's back when I was at the Court of Appeals, everyone cited Fast Airing v. Knight. It's a case, that says everything has to be raised, addressed, and decided by the lower court in order for it to be preserved. I don't think that's accurate because, trial courts don't always necessarily decide an issue, or they may not, allow it to be addressed at argument. But if it's raised, it still generally is going to meet preservation requirements. So I'll stop talking.
Yeah, I think Nate did a good job providing an overview. I always, the rule's been around a long time, right? And it's a fundamental tenet of appellate practice. And you can go all the way back to the 1980s. There's a Michigan Supreme Court case that I cite a lot. It's called Napier versus Jacobs. And, the court was quite plain. General rule of practice is that failure to timely raise an issue waives review of that issue on appeal. And so I think you should always approach, any case with that assumption in mind. As Nate mentioned, there are times when the Court of Appeals does have discretion to take a look at issues that haven't been properly preserved. Usually they're issues that are purely legal, that, don't require factual development. But, it's important to remember that's always up to the Court of Appeals to exercise that discretion. You should never assume that that's going to be an option.
And I think there's an argument that under Talos, that discretion may not exist anymore because all the cases that they exercise that discretion, there's a published one from as recent as 2019, George versus Allstate. I don't know that there's any in the last 3 years since Talos. And I think when you read that opinion and its discussion of Napier too, it's a pretty strong argument that there may not be that discretion now. It may be a hard and fast rule in civil cases.
And I think that the piece that practitioners need to especially keep in mind as it relates to this rule, and where I see people run into trouble sometimes, is that this applies even to things like, a statutory bar to a claim. So, something like statute of limitations. I've seen people at the appellate level say, well, but it's clear as day under the statute, the claim was barred. Even something like that needs to be raised before the trial court. I did want to ask about the exception, as I understand it from a lot of the case law, that the appellate courts have articulated the exception as sort of to prevent a miscarriage of justice. And where I see appellate courts address non-preserved issues, I think in my cases, I've only ever seen it as it would not change the result. So a court might say this wasn't preserved, but here, it wouldn't change because these are our thoughts. I'm curious if any of our panelists have ever seen that the preventing miscarriage of justice exception applied and it actually changed the result, because I don't really think I have.
I never have. No.
Yeah. And I would suspect that miscarriage of justice language kind of bled over from the criminal cases, and that
I think that's right.
panel would say improperly bled over from the criminal cases.
Yeah. I mean, really, all this goes to show is right. None of us have ever really seen it happen. And, as Drew mentioned, it sounds like the trend may be getting to the point where it's even more restrictive, if not prohibited. So, yeah, I think if everybody walks away with that sort of fundamental understanding, that's a good takeaway.
I think, to be perfectly frank, a lot of I've never seen it. I've never seen the miscarriage of justice exception applied to reverse in a civil case, or but I think part of the reason that it's ever even invoked in civil cases is kind of to save the skin of the attorneys who didn't necessarily preserve the issue in the first place. And so the Court of Appeals goes out of their way to just say, well, yeah, this wouldn't change anything anyway, so that it looks better for everyone.
Yeah, good point.
No, great points. I think Nate touched on something here, but the razor wave rule also says, it often brings up, addressed by the trial court. And I think you did mention that if the trial court doesn't address it, it doesn't necessarily bar you from raising it again on appeal. But what are some of the dangers of kind of presenting a kitchen sink almost approach to a trial court where you have so many different issues uh, and so many potential issues that could be on appeal. Are there dangers to raising all those just for preserving them, or any useful tips on drafting motions in that way?
Yeah, I'm happy to jump in here. I do think there's a risk in either saying too much or too little at the trial court level. Of course, the risk in saying too little is that, you might not have fully developed an issue such that it's preserved. But I think there's also a risk in what you described, Grant, as the kitchen sink approach. If it's just argument after argument and you're running out of space, right? We all know we've got the briefing limits, and you're probably not developing those arguments to the extent they need to be. Another issue that I see sometimes here is, are you actually asking the trial court for the relief that you later are going to ask the appellate court and say the trial court should have given us this relief? So, raising the argument, citing the factual basis that supports that argument, and then asking for the relief that you want the trial court to give you, or the three pieces that, if you're trying to get that bare minimum of having raised an issue adequately, I think need to be there.
Yeah. Oh, go ahead. Sorry.
I was just going to say the kitchen sink approach can be dangerous because the more issues you raise, the more of a chance that some of them will be inconsistent and can be used against you on appeal. If you don't win them all or lose them all necessarily, but the other side can say, if you're the appellant, they can say, well, you asked for this, and which is it? And if you're actually offering proofs for it and law and authority, like Adam said, you need to, you can put yourself in a bind.
Yeah, I think, and it seems obvious, right, the advice that we're talking about, but in my experience, I see a lot of lawyers have the arguments that they just, they think, well, what's the harm in raising it? It's pretty decent. So my response is always, we should really try to focus on, making the arguments that we think are, really good and that are going to give us a good chance of prevailing. And you have to be willing to let go of arguments that aren't as good. And sometimes you get client pressure, right, to make arguments that maybe aren't great. So yeah, I think what everybody's saying, I agree with. It really makes a ton of sense to, pick those, those good arguments that you think, are good, and that if you don't prevail on them, they're going to have a decent chance on appeal, and kind of jettison the rest of them.
Yeah, I think think about it. The way I like to think about it is it should fit in your introduction. If you can explain it, why do you win in your introduction, really briefly, succinctly, you don't need those other arguments. If you have to go through your introduction, there are 7 different reasons that I win, and you're going through these alternative bases, you're going to lose the court, and you're just going to waste everyone's time. And I think it is about paring down to what really matters. And it can be scary to think you're making a judgment call about what issues to raise, because if they're not raised, they're not preserved. But that requires doing the background work to understand what issues really are worth raising and what you really do want to make sure is preserved.
Yeah, I agree with all that. And I'll just add, I think this is a point where, client communication is really important. If we're going to leave an issue on the table, the client should be informed, and it safeguards against a lot of issues down the road of the argument. Well, why didn't we preserve that? That you might get on appeal, because arguments change and they change shape, and you got to make those tough calls. Because I completely agree, you don't want, here's 7 reasons why we win, in your intro. So I think communicating with is it.
So I think that's right. I don't know if my internet's bad or if Adam froze there for everybody, but
He froze for me.
I was wondering the same thing, but
I think Adam touched on this earlier. Then the other benefit, of course, of being selective is then you have more of an ability and more space, right, to more fully develop the good arguments that you have. So that there's that added benefit as well.
Sorry about that. I figure you guys can just fill in the blanks of what I was saying.
wasn't at the very end. So On that sort of expand, like on that topic of how much of an argument or how much do you have to really raise at the trial court? If you're thinking this case is probably going to go up on appeal, whether we win or whether we lose, somebody's going to take this up. How how much of an argument at the trial court do you have to be compared to what you think you might be making on the appeal, where you're going to have more space most likely, and you're going to have more time to really expand your argument with more case law? Is there a difference there?
I think there is. And I think that's part of the difficulty, right, in making a decision about how much you want to get into because, there's sort of a line between an issue can be waived if you don't raise it, but you can certainly more fully develop. You can expand argument on an issue as long as it was raised. So, you just sort of have to make sure that you're giving enough for the court to hopefully agree with you, but also enough so that you feel pretty confident that at least the contours of the issue have been sufficiently fleshed out so that nobody's going to accuse you of, of coming up with a totally new angle on appeal, because that's where you start to potentially get in trouble.
I think these are really hard choices sometimes about what arguments to raise on at the trial court. Grant, you mentioned, you have more time, more resources often at the appellate level to really dig into issues, and they might look different than they did at the trial court. There's also other factors like intervening case law changes that could happen between the time when the argument's presented at trial court and the appellate court, and those are the really hard ones because I've seen attorneys say, well, I got this. There's this great new controlling decision, and I mean the answer sometimes can be, well, why weren't you as creative as the attorneys in that case? Why didn't you raise it here? You also don't know what facts are going to come in or how they're going to come in. Whereas when you're looking at the appellate record, it's all much cleaner. So. And of also intervening decisions from the court, right? A court might later make a decision on issue A that really strengthens or weakens argument B, and you don't necessarily know that at the time it needs to be raised. So these are just all considerations. I don't think there's really a roadmap about how to weigh all of these. But the decision of what to raise at trial court, it can be very different than when you're looking at it on the appellate record.
I think that whole summary too gives people a good idea of why we have the final order rule and why interlocutory appeals are so tough and have to be you have to be very selective about the issues you take up because you just don't always know what the picture is going to be at the end. We're gonna get into interlocutory appeals and leave applications later, but that's a conversation I have a lot because a lot of my colleagues, they want to take up every order that they lose, which is what makes them good trial lawyers. But Court of Appeals is not going to help you most of the time on an interlocutory, and especially if it's not dispositive. And the complexity that Adam just alluded to is one of the reasons why they want to see the whole ball of wax at the end when everything's settled.
Yeah, and I think we might bounce around here a little bit, but since we just kind of mentioned applications for leave and interlocutory appeals, how how is that different from a claim of appeal with regard to what issues and how you can kind of present your cases through an application for leave versus a, final order claim of appeal?
So I think the way that I like to think about it is, so someone mentioned, I think it was Drew mentioned the idea of, is this going to be a dispositive issue? You do have to be really careful about what you're taking an interlocutory appeal on. And I think that it's getting harder to get leave granted. I don't know if you guys have seen this. I don't know that it's necessarily, across all types of cases, but at least in civil cases, I'm seeing more leave denials, I think. And I think part of the reason is there's, the court's pretty backlogged. And, just pragmatically speaking, they've got a lot of appeals of right that they have to deal with. And so it's a purely discretionary call whether they want to take a case on an interlocutory basis. So you have to have a really good reason why why it should go up when it goes up, on an interlocutory basis. Do you have the sufficient record? Is discovery closed? or is this a pure legal issue, maybe out of the gate that's, is dispositive of the case. But you have to be able to explain to the Court of Appeals why this should be considered now. It's not just the trial court is wrong. It's you have to explain why this needs to be heard now and not, 2 years from now when the case is closed. And I think that's where a lot of trial attorneys get hung up. They're like, well, but this is just so wrong. Like, I say, yeah, it absolutely is wrong, but the court's never going to take this. This is just this is some, run-of-the-mill issue that they see 1,000 times. They don't want to deal with this on an interlocutory basis. But if you can explain to them, why this is a novel issue or why this is likely to recur or, why this is dispositive of this case, and, it's just, there's no silver bullet, but, it's trying to frame it in the most constructive way to explain why it needs to be heard now.
Yeah, that's exactly right. And it's right in the court rule, right? And I always direct people to that when they start talking about their great interlocutory appeal. It's like, well, we really have to be prepared to show why would we be prejudiced if we have to wait until the end of the case. So, my experience, preliminary injunction type appeals, can be good ones because, it's hard to fix sometimes damage that's done. Discovery disputes, even sometimes, if someone's being precluded from getting access to evidence so that the case is going to be impacted in a negative way. But yeah, it can't be everybody that has summary disposition under C10 denied, right? And because I get a lot of questions about that. And it reminds me too that in federal court, right, you basically can't do it at all. I mean, we're fortunate to have, at least the option in the Michigan Court of Appeals, but I think it all goes to show, like Nate was saying, that yeah, you really have to be selective.
And I always emphasize too, pay attention to why your motion was denied, especially if it's a dispositive motion, because every once in a while you get lucky and the judge will tell you exactly what witness hasn't been deposed that would make the difference, or what batch of documents that need to be subpoenaed or whatever. And it's a heck of a lot cheaper a lot of times and faster to do the thing that the trial court wants to see done than it is to appeal and say, well, and a lot of times the first response is going to be that, well, we shouldn't have to do that discovery. The case is, there's no case. Well, if the judge thinks it's important and you file an interlocutory and try to tell the panel that's not important, it's a tough spot because this judge obviously wanted to see some more information. Sometimes it's the motion after the motion that really can do in the case if you're filing for summary on the defense side. And then if you lose that, then you've got a record more so than if you do it too soon. I think interlocutory appeals when they're bad, a lot of times it's not necessarily that the legal issue isn't understood well enough, it's just too soon. That's if I've seen one common theme with it's just it's you don't have to try the case necessarily, but if you're filing for summary and discovery still going on and they're saying so and so is going to say such and such a thing, get them on the record and then move for it and then appeal that.
Yeah, and a lot of times, interlocutory applications will get denied, just basically saying we're not persuaded of the need for immediate appellate review. But do you run the risk of the trial court taking that application being denied as something more than just being, hey, this is not, you don't have substantial harm, we can address this later? Do you run the risk of that decision looking like, well, the Court of Appeals says you're wrong?
Yeah. Some judges will interpret it that way.
Yeah. Well, I mean, the Court of Appeals is very careful about almost always saying we're not persuaded of the need for immediate review. But once in a blue moon, they will say that that there's no merit. I mean, they will issue an order that says there's no merit to this claim, and then you're screwed. But then there's a lot of the case implications and so forth. But yeah, I mean, I think there is absolutely a risk that the trial judge sees that the leave was denied. Okay, well, I was right, and I'm going to feel emboldened. I mean, that's certainly a risk.
Yeah, and I think what Drew was saying, if I understood you, Drew, correctly, like your point about sometimes when the court makes a decision, might give you a hint about something that was missing or a way to maybe the relief you're asking was too broad. Like I actually was talking to somebody who had a motion to compel denied, wanted to, was talking immediately about seeking leave to appeal. But the more he sort of explained the situation, it sounded to me like there was an opportunity to maybe go back to the court with a more narrow request, which not only would be faster, but might actually, give you what you want at the end of the day. Whereas going to the Court of Appeals, yeah, it's not only is it going to take a while, but you may not, get anything out of it.
This might be a secondary or tertiary. I agree with everything you guys have said, but another consideration too when you're thinking about whether to file for leave, might just be do you want to give the other side another 25 pages of briefing on your case? And I think of that because I've had cases where the other side has filed application for interlocutory appeal, and they say things like, well, this ruling was so wrong, and this is why that ruling screws us at this proceeding, and this is why we're going to be we're not going to have this evidence or not be able to make this argument at trial. And I'm reading it, I'm going, okay, great. Well, not only do I have a better roadmap to the rest of your case, but you've now made some concessions where if your application is denied, you've said you can't make this argument, or you've said X, Y, and Z will happen to you. That can be, I've cited back to that later, and the trial judge, after the leave is denied, has said, yeah, that looks pretty good. They've said it to the Court of Appeals. So, it's certainly not a primary consideration, but something to keep in mind if you're filing that application. You're putting more of your case theory and potentially making concessions that could play a role later on in the case.
Yeah, so switching gears just a little bit, just kind of want to step back again and kind of just talk about the record on appeal. This is called creating a record that works. And what really, could we just kind of give an overview of what is that record on appeal? What is the Court of Appeals able to look at? What are they not able to look at? Or what are some tips on making sure that you have a good record from an evidentiary standpoint more than anything?
Well, that goes back to the dichotomy between apps for leave and claims of appeal, first off, because when you file an app for leave, the record that when they're looking at the app for leave, the commissioner's office is not looking at the entire trial court record. They are looking at what you append to your application for leave. So it's really important to, at the trial court level, on summary disposition, for example, make sure that you've appended everything that you want to potentially be considered to that motion or, in some other fashion, because that record is going to be pretty limited on the application stage. It's a lot broader at the final order stage when you take a claim of appeal. It's everything that's been introduced in the trial court. And others can get into that as well. But I do think it's really important to draw that distinction, because I think that, there can be the misconception that when you file an interlocutory appeal, you can get the Court of Appeals to consider everything that was in the trial court. And it's not quite that simple.
Yeah, I'm thinking like most of my experience or where I've had issues where we've had to navigate this is so like on motions for summary disposition, right? Either whether you're filing or responding. And even if you have a motion for summary that's granted, let's say against you and you're going up on appeal, it's pretty well established that summary disposition record, even in a appeal as of right scenario, it's pretty much frozen in time. So you really have to be, cognizant of the fact that if you're seeking to create a, genuine issue material fact, or even if you're the move-in and you're trying to argue that there isn't one, that the documents, the deposition testimony, you want to make sure that all of that gets before the trial court because, at least in my experience, the Court of Appeals is very hesitant to look beyond what was presented to the trial court at the summary disposition stage.
Yeah, that's absolutely right. And related to that, there's a problem that I know a lot of trial practitioners deal with, which is individual judges, particularly in Wayne Circuit, I think it happens other places too, have these protocols that limit how many pages you can add as exhibits to your summary disposition briefing or to any briefing for that matter, which I think is absolutely ridiculous because how can you be limited to 20 pages of exhibits or whatever? They're putting some really, arbitrary and artificially low numbers on these. it's not really fair to litigants to be limited in that way as to how they present the record. But it's really important to find ways around that if you need to, because again, you're limited to what's been presented. And if all you presented is 20 pages of your best, testimony, like that may be enough in some cases, but you often need the full depositions. And, if there's any way you can get full deposition transcripts and so forth, as part of the record, that's really important because it is frozen in time, as Phil said. You can't take reconsideration and add stuff. You can't bring stuff up at oral argument and assume that that's going to be considered. It's got to be in the briefing.
Yeah, it's a good point, Nate. When I've run into that issue in Wayne County Business Court, I've filed a motion for leave to file more exhibits and attach all the exhibits I want to that motion, so that at least they're getting on the record. Because we're, as appellate attorneys, I think we'd be remiss not to mention there's a court rule on this, right? For appeals as of right, MCR 7.210 says the record is documents actually filed with the court, transcripts of proceedings, and exhibits introduced at trial or an evidentiary proceeding. Our hearing. So if it's not filed with the court and it didn't happen in a transcript and it wasn't an exhibit introduced, the Court of Appeals just isn't going to look at it.
I've seen people also just file a transcript as a standalone document with no explanation of why they're filing it, and then tie it into a motion later. And then I don't know that flies everywhere with every judge, but I've seen it done. And then if it's not rejected, that's in the record, and you're good.
And there's the Maiden versus Roswood case law that says the trial court has to consider everything then filed in the action. And you can argue that it was filed in the action, even if it wasn't filed with the motion.
Although that reminds me, Grant, you mentioned that. And again, it's like a lot of it could depend on the judge, but I know the Court of Appeals has impressed that judges don't have to go searching through the record, though, right? So if you don't bring a deposition portion to the judge's attention in connection with a motion, even though it's in the record, maybe it'll be considered, maybe it won't, but you're at least kind of, to me, playing with fire a little bit there. And I've seen people get stung by that too.
Yeah, and another thing where people can get stung, what's and a lot of times people think that motions for reconsideration are a time to raise a new issue, raise a new argument. I think we could pretty quickly say that that's not the case, but I don't know if you want to expand a little bit more on how the case law is going with trying to make new arguments or present new evidence with a motion for reconsideration as opposed to with your initial motion.
But it definitely isn't part of the record for the initial motion, but there is this little sliver of hope for people that if you're stuck with that position, it's like, say you're appellate counsel, you came in late and there's something you really, really want to talk about. You can always argue on appeal that it was abuse of discretion to deny the motion for reconsideration, independent of the underlying motion. And I think that's how you have to approach it if there's things that you really need to show the trial court and the Court of Appeals. Obviously, the best way is not to be in that situation, but sometimes you're there and there's nothing you can do about it. And if you are, I think that's the better route, is just admit, like, hey, this was introduced for the first time on reconsideration, but it was such a good point that it was an abuse of discretion not to reconsider.
Yeah, I think that's right, Drew. You really have no choice, I feel, but to at least give it a try at that point and just give the appropriate cautions to, trial counsel, the client, that, look, this may not work. But yeah, I think you're right. I think it's definitely a good advice to at least try, because the trial court may consider that new evidence, and in which case then you're fine. If the court doesn't consider it, then you're right. Maybe you do have an argument. Maybe at least the Court of Appeals is willing to overlook it, or you argue that it was so key, or the new argument was so key that it is an abuse of discretion to deny the reconsideration.
Yeah, I mean, I think the key is it's discretionary. So, I mean, you never want to be in a position where your arguments are hanging on the discretion of the trial court, and it's really hard to overturn that. But if you need to, because it hasn't been properly raised, then do it and own it. I mean, I think that's as simple as it is. Don't try to pretend to the Court of Appeals, a year later that this was properly raised, you got to own it. But if you need to raise it, you need to. But try not to wait, any way you can. And I mean, by that same token, don't wait until argument, it's better than nothing, but it's also, entirely discretionary whether the trial court considers arguments raised for the first time at oral argument. So, it's entirely proper for the trial court to say, well, you didn't raise this in your brief. I don't really care what you're saying now. If you haven't raised it before, that's still discretionary, So again, get it in your summary disposition briefing.
Yeah, and actually, sorry, I was just saying, this is probably for me, in terms of issue preservation, this is probably what I see the most occur. People will get summary disposition granted, say, and then the judge will say something or something will happen and they're like, oh, well, what about this? What about that? And it'll lead down the road of arguments or evidence that wasn't presented. And so then you got to figure out how to navigate it.
Yeah, I was just going to say, I think one other way I've seen motions for reconsideration be helpful, we've covered just raising new arguments. It's rarely going to work there, but it can be a vehicle just to get a document or two into the record. So where I've seen this is sort of a surprise dismissal or ruling before trial on a ground you maybe didn't expect, and you made your arguments that you want to appeal, but wow, exhibits 3, 4, and 5 that we might have used to support that point, we weren't going to bring up, they hadn't been authenticated yet, we were going to bring them up at trial. Let's at least just attach them to this motion for reconsideration. So I don't have the preservation issue. I can still I can still say I made the argument earlier, but Court of Appeals, here's these other documents too, and at least they're in the record, so you can at least point to them. And then if at that point on appeal, the other side's saying, well, some of their evidence, wasn't raised earlier. Well, if that's what they're arguing about, they're not on the strongest grounds either. So it can sometimes be your last shot to get something else, a document on the record, even if it's not going to be a very effective way to get a new argument on the record.
And we've talked a lot about applications, or we talked previously about applications, and trying to, if you have like an issue where you think this is such a big winner, we should have won this. Are there ways to creatively get in front of the Court of Appeals not going through an application for leave? And are there ways to stipulate to a judgment and get an issue up on appeal earlier than you would otherwise?
Yeah, you used to do this a lot with no fault cases in particular. So a lot of times you'd have one discrete legal issue, and then it really is the only reason the claim's being denied. And then if that doesn't go in favor of the insurer, it's like, well, would we have a trial over? We're not going to have a trial over the amounts of services and whatnot. So I did that many times where you'd stipulate if you can agree to a number. Now, sometimes you can't agree to a number, and then that's the real problem. But the key is if you leave nothing for the trial court to do, then you're going to have an appeal by right. That's really the bottom line. So if you
got to be careful about what that consent judgment said. If you reach, you got to make sure there's specific language in there preserving the, carving out that right to appeal. But definitely. Yeah, I've done it plenty of times, and it's pretty effective. It's a good way to short circuit the process.
And also making sure, right, that things aren't dismissed without prejudice. That can always be something that will trip you up. But yeah, well done. Yeah, consent judgment or stipulation can definitely be used to get up to the Court of Appeals.
One other scenario where I've taken a similar approach following an injunction ruling. So, as we all know, one of the elements of an injunction is likelihood of success on the merits. And in like a single issue case or a case that's pretty limited, you'll sometimes get a real strongly they feel about the merits, especially if it's something that in a case where it was very clear.
Eat that a little. You've been freezing up. Was that everybody that he froze there a little bit at the end?
Yes, he definitely froze. I think he's still frozen.
We lost Adam.
Great point, because he always does. But I do. So
Before
we
we move
have.
on, I just want to add about
Yeah.
getting in front of the Court of Appeals right away. Don't forget about the special rule for governmental immunity. It gets overlooked every once in a while, but if you're representing a municipality, you've argued immunity and lost, you've got a direct ticket.
Yeah, limited
Yeah,
to
that's
Here to
right.
stay.
Don't think you can shoehorn other stuff in there though. I
That's
get
right.
people doing that all the time. They're like, "Well, I raised 5 issues in my MSD and I want to get them all up." I'm like, "Nope, you can get the immunity issue only."
I
So
think they actually amended the court rule to say it's limited to the
yeah,
issue of immunity because that people were using that.
yep.
Well, and I don't know if this administrative order is still open, but I know the court within the last couple of years, it came up during one of the appellate practice section council meetings. There was a proposal. I think the court was at least exploring whether to maybe even remove that ability to get up to the Court of Appeals as a matter of right and to make all of those appeals even by leave. Hopefully they don't do that because I think I think there are a lot of good reasons for immunity issues to
All right.
be appealable as of right, but
I mean, it's immunity from suit.
It was a couple years ago. I actually did an opinion on behalf of some governmental entities against it, but they did talk about changing the court rule, and there was a lot of public comment, and it never went anywhere. Thank goodness.
good. Yeah, that's good.
You guys hear me now?
Yes.
That's better.
Sorry about that. I'm not in my usual office. I'm traveling this week. The point I was making earlier is just that sometimes you might want to try to lose really quickly and get to the Court of Appeals. If you've been at an injunction stage, you know which way the court's going to go on the merits, and you need to be careful about it, though.
So yeah, we've gone through a lot of the different motions. I do want to shift a little bit towards trials. And I know we discussed this before, but kind of first want to just kind of discuss um what are the values of doing a motion in limine versus objections, or do you need to, if you filed a motion in limine, how much do you need to object if it's been denied? What are some good tips for making sure that you still have preserved that issue if you're going to trial and thinking that this is going to go up on appeal?
I think you need to do both, depending on the situation. But I mean, a motion in limine can be very important because there are certain things that can come in. If you say you don't file a motion and then stuff comes in, it's really hard to undo prejudice, right? I mean, sometimes, there's just really bad stuff that happens at trial. And if you haven't raised it in motion in limine ahead of time, it's a lot harder to say, well, we knew this was going to happen, but we didn't do anything about it until after it came in, and then you object. But you also have to object contemporaneously. I mean, you don't want to just be constantly objecting, but you do need to even if you file the motion in limine, even if it's been denied, I think you still need to be objecting contemporaneously when the stuff happens at trial, because otherwise you're not really giving the court, think about it. You're trying to give the court an opportunity to fix it, and maybe it's not fixable, but you want to give the court that opportunity when it happens rather than just sitting on it.
Yeah, and then if you just rely on the motion in limine, you could be caught in a situation of having to demonstrate that that was really intended to be the court's final say, right? Which may or may not be the case. And there could be trial developments that, may change that, right? But yeah, I mean, to me, the only possible exception to if the finality, but you still have to be careful and take a look at it. But expert challenges obviously are primary areas for doing the pretrial motion and having the Davis Fry hearing. And, it may be that your obligations at trial are a little bit reduced just because of the nature of those. But yeah, I think that Nate's right. You need to, if you're going to file a motion in limine, it can be helpful because you get a chance to brief it and flesh it out. But you really have to be careful about, whether you should be making that objection again and getting it on the record during the trial.
I would just emphasize there is case law that says you don't have to have pretrial motions in limine. You can preserve an issue just by an objection. Obviously your mileage is going to vary depending on the issue and the evidence that you're dealing with. But don't get too caught up in feeling you got to file a motion on every single piece of objectionable evidence, because there is a risk too of feeding the other side issues sometimes, or arguments, or ideas that maybe they weren't thinking of they're going to use it that way necessarily. It's rare, but if you over motion a case just because it's a big case, there's that possibility that maybe you keep your powder dry and wait and see if this comes up. Maybe it doesn't come up, or it doesn't come up in the way you expected. Maybe you don't want to file that motion.
Yeah, I think that's a great point. I think you need to make sure that you're tailoring your motions to the case. Don't just be like, well, I have these 7 stock motions in limine that I always file.
Yeah.
Make sure that, if you're filing, I mean, some of them you kind of need to file, like, if you've got a wrongful death case and you know that the other side's, going to appeal to sympathy, you need to file, a golden rule type of, reptilian theory, motion. But you want to tie it to something that's happened in the case. Don't just say, well, I think they might do this at trial. Say, well, they've done this at X deposition. They've made these arguments before. We anticipate they're going to say this in front of the jury. The more you can do that, the more credibility you're going to have at the trial court, and the more, reasonable you're going to look. Don't just file motions that are like motion in limine to prevent evidence that hasn't been disclosed. I mean, it's kind of standard. It's like, yeah, of course that shouldn't be there, but you can deal with that as it comes up. Just tailor it to the case.
I just add caution to be mindful about what your ruling is on these pretrial motions. I think a lot of us have experienced that trial court judge's favorite ruling can be taking something under advisement. So watch out for the contours of the ruling. Does it mean it needs to be re-raised after certain evidence has come in? I had one situation once where a trial court excluded us from presenting evidence on an affirmative defense. We argued on the morning of the first day of trial, here's actually another reason that evidence might be helpful. And the judge said, well, you know what I think about the issue, but proceed at your own risk. So in my mind, I'm thinking, well, shoot, I know we're not going to win on this issue, but he also just told essentially the appellate court that we had the opportunity to make the record. So we have to sort of spend a bunch of time on this issue that we know we're not going to win on. So, something to keep in mind is what's the scope of the ruling you're actually getting.
Yeah, and motions in limine that aren't really motions in limine. They're just pretrial motions that are called motions in limine. I think of a motion in limine kind of, there's some evidence that is so prejudicial that the mere mention of it would, destroy my case, not just, well, they can't bring this up because they're not allowed to. So kind of thinking about that when you look at motions in limine versus just pretrial motions or things you might be able to work out with the other side even.
And be careful of motions in limine to exclude the case. A lot of times trial counsel will have an idea, like if we can knock out this piece of evidence, the whole case falls apart. It's like, yeah, but that's a C10 motion. If you got time under a scheduling order, file it as a C10 motion. If you don't, maybe you got to file, directed verdict after the close of their proofs or something like that. But that rarely flies. You rarely are able to jam that square peg into a round hole and actually win a case on a motion to eliminate.
Yeah, and even in that case, if you do win it, you might end up losing it on appeal because you shouldn't have filed it as a motion in limine. You should have filed it as something else.
And then they get all sorts of objections, and they didn't get the 21 days to respond with their rebuttal burden and all that.
I don't know if you guys have any good tips on how to object or how to make an offer of proof at trial, or even just explain what an offer of proof is, especially when it comes to how it's looked at from an appellate perspective.
So I, no great advice about how to make the offer of proof, but I know, like when I think of somebody needing to make an objection that is going to be important potentially for an appeal is, making sure the objection is, of course, timely, that, you don't wait until the testimony comes in, but making sure that it's not only timely, but try to be as specific as you can about why, the evidence shouldn't be coming in. And hopefully you're prepared that, some testimony is going to probably be coming that's harmful. And so you're ready with, whatever the court rule is, but just trying to be as specific as possible so that you have a record that on appeal we can look at.
Yeah, I think related to that, there's a tension between wanting to be cooperative and wanting to work with the trial judge and not piss them off, for lack of a better term, and making sure that you're creating the right record. And I think, I understand as an appellate attorney, we can sit back and say, well, you should have done this, you should have done that. But I get it. You're in the courtroom and you've got an annoyed judge who doesn't want to hear from you. It can be a challenge, but you need to find a way to get it in the record. You just do. I mean, you be as succinct as you can. And, most judges will respect you if you just say, Your Honor, I just need to make a record, and just be quick. You got to do it. Don't feel like, oh, I should just move on because I'm worried about making the judge mad. But, you just do it as quickly and succinctly as you can and be respectful.
Yeah, and also that reminds me, in making sure that it is getting on the record, right? I had an experience years ago that I was telling this group about earlier about. There's a sidebar discussion in Oakland County Circuit Court years ago with with the video recording, and so attorneys approach the judge. The switch goes on, it muffles everything. They had a discussion about something. Didn't end up being a huge issue ultimately, but it was a discussion about an issue that didn't end up being in the transcript because they didn't remember to go back on the record and make sure that whatever came out of that sidebar would actually show up in a transcript.
Yeah, and that's something to keep in mind too. Like an appeal I'm working on right now, there's a lot of discussions, and then there's, oh, I don't object except for what we just talked about. And
Hmm.
I'm looking at it going, I have no idea what you guys just talked about, and the Court of Appeals is going to look at it thinking the same thing. So I think that's something to really think about, of just putting it back on the record, especially when you're in trial. I know it's, fly by the seat of your pants when you're in there, but um, that's something to definitely keep in mind. Uh, one thing, I think we mentioned sometimes sitting in on trials or as appellate counsel, and obviously I think we can all say that that's something that's invaluable from an appellate perspective. Do you guys have any tips of convincing clients that it's a good idea? Because that's really, I think, where a lot of I've heard, from colleagues and own experience, that's the big hurdle in getting an appellate attorney at the trial.
So I think you have to be able to demonstrate your value. Explain to them you need to be able to succinctly explain what you're actually going to do. And that can be, I mean, obviously, for me personally, it starts at voir dire. If I'm sitting in the trial, I'm sitting in a different part of the courtroom and I'm going to be watching the jury in a different way. Usually I'm not sitting at counsel table. And so if I'm sitting in the back of the courtroom, I'm going to watch the jury pool. I'm going to watch everything about them. And I may not be a jury consultant, but I've still got eyes and I can read people, and you can add value that way. You got to watch, the types of questions and how the jurors are responding to voir dire. So I think you have to be able to, go through the trial with the client and explain, this is what I'm going to do here, this is what I'm going to do there. It's not just I'm sitting there waiting for a legal issue to pop up, but being proactive, throughout, trying to just add more than just a preservation value, because I think there is a lot you can add that goes beyond a pure appellate preservation. Just having a set of eyes in a different part of the courtroom.
And I think, I mean, I don't have a ton of personal experience being embedded at trial, but I feel like jury instructions are a place where, it's a big job. It can be carved out. It's a lot of, legal analysis that could be involved, research. So I know that there are people who, if they are embedded at trial, maybe handling jury instructions is totally up to that appellate lawyer, right? In terms of what to object to, even making the arguments to the judge after everything's briefed. So I know that's a real important, I think, opportunity for having an embedded appellate attorney providing value, it seems.
Yeah, and arguing evidentiary motions that might come up in the middle of trial, arguing the DVs. You got to be really careful, about appearances. You don't want to be looking like you're piling on a plaintiff or something. You don't want to make it look like this big bad corporation's got, a bunch of lawyers sitting around the courtroom, spying on people. But, so you don't necessarily want to be arguing stuff in front of the jury. You don't want to be popping up, in the middle of trial. But when there are discrete issues outside the presence of the jury, having that appellate attorney there to argue and make sure everything's, properly preserved is, really valuable.
Yeah, and to the point you just made about the DV motions. If of course a lot of this too, it depends on how big the case is and the clients. There has to be a lot at stake. But it reminded me, we don't do a ton of med mal anymore, med mal defense. But I have been involved. It's been a long time, but where we're working with another firm, and we literally did carve out the directed verdict motion, and we did a written one. It was very comprehensive. We had the daily transcripts because it was a big enough case that it justified the expense. And I know the trial lawyers that we were working with, they appreciated just not having to deal with it.
Right. Well, and to that point, even if you don't have the transcript, having that appellate attorney in the courtroom taking notes contemporaneously, able to represent in the briefing, you're filing a DV, where you can actually represent this is what came in during the case in chief, is so valuable, because then there's just one less layer of the trial attorney's telling me and I'm writing down. You're getting it directly from the courtroom, and so your recollection is going to be a lot cleaner. And there's value to the client, I think, in providing daily reports as to what's happening in the trial from the appellate attorney's perspective, because you're doing something, you're able to focus on the bigger picture of what the trial looks like, how it's developing, how the demeanor of the judge, how the jury's reacting to things. You are going to see things that the trial attorneys, who are so, focused on doing their job, are not going to see, and you can convey those to the client. So, the client has a really good risk assessment of how things are progressing.
I think we're just about done here. I don't know if anybody has any parting thoughts other than just make sure that you have a good record and make sure you've raised your issues. But I don't see any general questions. So unless anybody has anything specific to add.
I would just reiterate the Court of Appeals is an error correction court. So trial judges have to have an opportunity to avoid the error. Just keep that in mind whenever you're thinking about whether something's preserved or what to do to preserve it. You got to have a chance, and the best way to preserve it is to win it. So I always tell my colleagues that as well. Then if you approach it that way, then you're probably going to make the record that you need if you don't win it to take it out.
Yeah, I think that's a really good point. And apart from that, though, I very much thank my the panelists here. This was very insightful, even just for me, and I hope everybody attending got some great use out of this. It's always interesting to get other perspectives and to see this issue, see these issues talked about in a more open way like this. So I really do appreciate you guys taking your time out. I know we're all busy, and this is really thank you for participating and being here.
Absolutely. Our pleasure.
Thank you to
this.
Thank you.
Yeah, thanks all.
Yeah, and thanks everyone for coming. I don't know if I have to do anything really to sum this up, but yeah, please. I think we have the different events coming up that are on the screen right now. Again, if you're not an MDTC member, I would encourage you to join, and if you are, I'd encourage you to go to any events that you can. They're always a good time to talk to people, learn some things, and really expand our defense bar here. So with that, I think thank you all for coming, and thank you all for participating.
All right. Yeah. Thanks to all of you for joining. I appreciate it. All right. Take care, everybody.